Hi, everyone. This is Rachel Haynes-Pinsker. I'm the Legal Services Manager at the Pennsylvania Coalition Against Domestic Violence, and I wanted to thank everyone for joining us this afternoon. Our speaker is John Wilkinson. He's an attorney who's a former prosecutor, and he is an attorney advisor with AEquitas, the Prosecutors Resource on Violence Against Women. As an attorney advisor, he presents on trial strategy, legal analysis, and policy, and ethical issues related to violence against women at the state, local, national, and international level. So welcome, John, and thank you very much.
So we're going to talk about Pennsylvania's new strangulation law. You guys have a great new law. We'll talk about strangulation a little bit in general and specifically about the new law, which is going to be a huge asset as you go after these dangerous cases. I think we have traditionally, maybe not traditionally, but in the past, and I know I'm one of the folks as a former prosecutor in Virginia that didn't pay as close attention to strangulation as I think we should have. It is extremely dangerous behavior, and your new law, I think, puts it in appropriate context and gives you some help and some tools to go after this very dangerous behavior. So we'll go ahead and talk about that in general. I am, as Rachel mentioned, I'm an attorney advisor with AEquitas. We're the Prosecutors Resource on Violence Against Women. Please reach out to us for any assistance you need. We primarily assist prosecutors, but we help out anybody who reaches out for help. So we get a lot of requests for help from prosecutors, police, advocates, medical, mental health folks, anybody who's engaged in violence against women issues. Domestic violence, sexual violence, stalking, human trafficking, abuse in later life, witness intimidation, prison rape elimination, anything along those lines. So please reach out to us. You'll have my contact information and our website, and we hope to be able to assist you with any of those issues. We are funded by the Office of Violence Against Women at the Department of Justice. They pay for us to do these things, so there's no cost to you when you reach out for help or when we do these presentations. They don't necessarily agree with everything we say, but you can decide for yourselves. And this presentation has been, a bunch of people have contributed to it, and some of the things we've gathered from the internet under fair use claims. Specific acknowledgments in help with this strangulation material. Dean Hawley, who's a medical examiner out of Indianapolis, George McLean and Gail Strack, who have written this article, as well as the additional article on strangulation. And Gail Strack, of course, is with the Strangulation Institute and the Alliance for Hope and does tremendous work related to strangulation, is also there to help. And I think she did help in drafting Pennsylvania, not in drafting it, but she assisted the folks that were drafting Pennsylvania's strangulation law. And is a great resource. All right, so after today's presentation, we will be better able to recognize the danger and lethality posed by strangulation. So it happens a lot in domestic violence cases, and it is not routine behavior. It is a very dangerous behavior. It is a risk factor on lethality, danger assessments, and we need to pay close attention to that. And we also have to recognize that when a victim is strangled, that they really do need to receive a medical assessment because the behavior is so dangerous. So we want to make sure that we recognize how dangerous it is and make sure that all the proper precautions are taken with regard to victims. We'll be better able to identify crimes that qualify under Pennsylvania's new strangulation statute. So we'll go over that statute and talk about what the statute requires for conviction, what it criminalizes, and what it enhances. So there's going to be a series of things that basic strangulation is going to be a misdemeanor, and then if it's against a family or household member, it's going to be a felony, and then certain other things make it a felony, and then there's a separate category. It'll be a felony in the second degree for certain offenses and a felony in the first degree for other offenses. So we'll go over all that, but we want to make sure that we charge appropriately, recognize what is going to enhance the penalties, and make sure that we investigate properly so that we gather the evidence and information necessary for the proper charge and a conviction, hopefully. We're going to be better able to document all the signs of injury consistent with strangulation. That's going to be very important to help us prove that an individual was strangled and that it fits under your new strangulation law. And so we'll go over a bunch of the things that will help us understand and prove what this offense requires. And we'll also be better able to effectively investigate and prosecute cases involving strangulation. And we'll go over those various strategies and different things as well. So this is coming up blank, but I think it might just take a minute to fill in. And I have it here. This is a quote, yeah. And maybe I just needed to keep clicking probably. Strangulation is often one of the last abusive acts committed by a violent domestic partner before murder. This is a quote from a report out of Minneapolis from the Hennepin County domestic fatality review team. And they recognized as they were going over their domestic violence fatalities that there was often strangulation involved just before an individual was murdered. And sometimes it is the cause of the homicide, but they recognized that this was happening a lot. And Minnesota was one of the states early on to pass standalone strangulation statute to criminalize this and recognize the danger of this behavior. It's just a great quote, and it reminds us this is extremely dangerous behavior on its own because the neck can be so fragile and damage can be done that's so serious. It can cause unconsciousness, it can cause death, it can cause delayed death that we don't realize that's going to happen sometime after the actual strangulation incident. So it's extremely serious. It's also extremely serious because it represents a significant risk factor for lethality, for death in homicide, in domestic violence relationships. So we want to pay attention to that for that reason as well. It is probably going to be one of the last things that's going to happen before the domestic abuser is going to actually kill his victim. And it reminds me of an argument I used to make when things would get to that degree. You know, we'd often see escalation in domestic violence cases where an abuser used to be able to control his victim through verbal abuse, through demeaning and belittling the victim. And then when that didn't work, he'd have to grab her and shake her. And when that didn't work, he'd have to slap her and hit her and punch her. And when that didn't work, he'd have to strangle her. And when that doesn't work anymore, he's going to kill her. That is how this goes. And this quote, I just think, is a great reminder of how serious this is. And Pennsylvania clearly takes this seriously, and as represented in this new statute, which is really a good statute. Virginia has passed a statute that's not nearly as good. That's where I was a prosecutor or an assistant Commonwealth's attorney. This is a much better statute, and we'll talk about that. So just to talk about strangulation in general a little bit, it is a form of asphyxia. Asphyxia is really just depriving the body of oxygen. So strangulation is that form of asphyxia characterized by a closure of the blood vessels and air passages of the neck as a result of external pressure on the neck. So that's typically what we think of in strangulation. You're pressing on the neck, and really what's commonly going to happen is it's going to affect those veins that are, the arteries rather, that are taking oxygenated blood to the brain, and the veins that are taking deoxygenated blood away from the brain back to the heart. And that's how this works. A lot of our victims will describe strangulation as being choked. And technically, choking is different. That's when something, like you eat a hot dog and it gets lodged in your throat, and that's when you're choking. It's something internal that is causing the blockage that is preventing you from breathing or the air getting to your lungs or brain. Strangulation is from the external force. And so we just want to recognize people use the word choke and strangle interchangeably. So if they're saying choke, obviously they typically mean strangle, but we want to clarify that. We don't want them to be telling us something inaccurately. Why is strangulation associated with domestic violence? This is a study from 2001 of a small group of 62 women who were in abusive relationships in Los Angeles and Dallas, and they found that 68% of these 62 women had been strangled as part of their abuse. That's a huge, high, alarming number, and that's also why we have to pay attention to it. They found that it was 5.2 years into to the relationship before that first incident of strangulation occurred. So a little ways into a relationship, that there was on average 3.1 years of prior abuse. And this probably fits with folks who are working with victims of domestic abuse, that you see, you know, the relationship doesn't start out immediately with abuse. Sometimes there's signs before maybe you get married, but the relationship itself doesn't start out with abuse. There's some onset and there's some prior abuse, and then they reach or graduate to strangulation. So we want to pay attention to that escalation. That can be important, and it is dangerous. 87% were threatened with death during the strangulation event, and 70% believed they were going to die during that event. And then symptoms increased with multiple incidents. So medical folks can tell you about some of the symptoms related to strangulation. I mean, there are some obvious ones that we'll talk about, where you have a hoarse voice, or you can't swallow, or it's painful to swallow. You'll see victims who are constantly spitting on the ground because they can't swallow. The saliva is gathering in their mouth. There are more and more symptoms, but there's other ones. There's neurological symptoms. Victims might appear to be acting out in a way that we don't understand, and it could be due to repeated strangulation. It's a very frightening, terrorizing event. It's the ultimate act of control, and the victims are going to respond that way, and we just need to recognize that. But the more it happens, the worse it is for the victim, and the more symptoms that medical folks will see. So women who are strangled by an intimate partner are more than 7 times more likely to become the victim of homicide. So it's an incredible risk factor, and it increases that risk of lethality. And it's understandable when you reach that point where you're grabbing someone around the neck and strangling them. I used to think that it was incredibly frightening because this is somebody who's completely out of control that's strangling somebody and has completely lost control and may injure or kill that person. But I have seen folks who strangle people and they're in complete control. They know exactly what they're doing, and they're doing it to control their victim. And it's that ultimate act of control. And that's as frightening as the person who's lost control. So they know what they're doing. It's an incredible risk factor for homicide. We do need to pay attention to that. So anytime somebody reports that, yeah, he choked me, or yeah, he put his hands around my neck, we're going to ask more questions about that. We're going to start to ask more about the history of that relationship and what sort of escalation has been going on, because I'm very concerned about this person. And there's instruments that will help us. The danger assessment, Dr. Jackie Campbell's from dangerassessment.org, the Maryland Network Against Domestic Violence Lethality Assessment Program, or LAP, that officers use. They'll get into that. We got to follow up and ask more questions when we identify that strangulation has occurred in a domestic assault. There's a couple types of strangulation. Hanging is, usually associated with suicide, and someone's using a noose around their neck. The most common one, and the one that we're going to see most often in domestic violence cases, is the manual chokehold, where hands around the neck are used, and a ligature, which is just a rope or a cord or something that someone uses to wrap around someone's neck and then pull. They use that too. The one other thing about hanging that medical folks have alerted me to is that when you have signs of strangulation, the other types of strangulation that we're looking for around here, hanging is maybe going to have more injury up around the chin and upwards because of how people are hung. But that strangulation that occurs maybe in children or in adults, where the abuser literally lifts them off their feet, where you can imagine that in a child and also in an adult, that it might look like a hanging injury in those situations as opposed to what we typically expect. So we just need to be aware of that. So here is Pennsylvania's new strangulation statute, and they define the offense of strangulation as a person commits the offense if the person knowingly or intentionally impedes the breathing or circulation of the blood of another person by these two methods: applying pressure to the throat or neck, or blocking the nose and mouth of the person. So a couple things I just want to think about from this part of the strangulation statute. Knowingly or intentionally. So that typically means we have to prove that they intended to do these things: impede the breathing or circulation of the blood. Now, a person naturally intends the natural consequences of their acts. So when you're doing that, my argument is going to be, of course, you're intending that that person is not going to be able to breathe or the blood flow. You might get into a little bit of argument there, but I don't think that should be a big issue. That's going to be how you prove that. It's circumstantial evidence. If you're doing this, that's what you're going to cause, and you know you're going to cause that, and so, of course, you're intending that. The other part is applying pressure to the throat or neck. That's what we typically think of when we talk about strangulation, is hands around the neck and applying that pressure. But they've also included blocking the nose and mouth of the person, and that's really important, and that is a great additional element to have in your statute, because that's also what sometimes people do. We're going to call it strangulation, and we're going to charge it. It's incredibly dangerous, too. You're trying to prevent the person from breathing. It could be something like this. It could be literally holding their mouth and their nose, whatever it is. It's dangerous, just as dangerous, and we want to make sure that we recognize that, and it's great that it's included here. So that's going to make it easier to prove that they intended to impede the breathing by blocking the nose or mouth. All right, so physical injury. Here's a couple other little caveats included in the statute, and these are also good. The infliction of a physical injury to a victim shall not be an element of the offense. So that's a huge bonus, because we don't always find visible injury in strangulation cases. It doesn't mean that injury, some statutes do require that you have injury, physical injury, bodily injury, and that doesn't mean that it has to be a visible injury. It depends on how a statute is written. You don't have to show it at all, so you don't have to worry about that. But even if you don't have physical, visible injury, victims can report to you symptoms of injury, such as a sore throat, or such as an inability to move their neck without pain, or difficulty swallowing. Those are going to be important things to demonstrate that there was injury in these cases. Even though the statute doesn't require us to prove that or to show physical injury, we want to show it to convince the jury that not only did this happen, but it's extremely dangerous behavior. So just because it's not required doesn't mean we don't do a thorough investigation, we don't ask about these things. We want to prove it up every way we can, but we're not required to show physical injury, and that is an asset, because sometimes you'll get people that hang up on that element. They'll be like, well, there was no marks or there was no redness, and if somebody was really strangled, I'd expect there to be something there. Expert testimony can also assist us in this regard, because medical professionals who are trained in strangulation and assessing injury can tell you that you often won't see injury. Or a lot of times that day or that evening when we're looking, the officer might not be looking in good light, someone might be wearing makeup, or they might have long hair or be wearing something that's covering up injury, so we might just miss it. So we need to do those thorough investigations, but we often don't see injury, visible injury, and we need to remember that. Doesn't mean that there wasn't strangulation, doesn't mean that it wasn't dangerous, doesn't mean that the victim is not injured. They could still be reporting symptoms of injury, and so we want to recognize that and be on top of that. The lack of physical injury to a victim shall not be a defense in a prosecution under this section. So they're not going to be able to argue that they failed to prove physical injury, therefore you must acquit the person. Lack of injury is certainly going to come into play in these cases, because the defense is going to say things like, you can't really believe this victim, because if someone was strangled, you'd see something. You'd expect there to be injury. Or if she really passed out from the strangulation, that had to be serious, and so we should see marks. They'll still be able to argue that. I'm certain that they'll be allowed to argue that. They just simply can't say, because we failed to show physical injury, that you must acquit, which is true in some other states and some other statutes. The next section, affirmative defense, it shall be an affirmative defense to a charge under this section that the victim consented to the defendant's actions as provided under Section 311, which talks about consent, and we'll talk about in a second. So if someone consents to strangulation, where I've seen this before is typically in a sexual assault, and someone claims that, no, this was consensual, we enjoy rough sex, and strangulation is part of that incident. So that could be a defense, and we'll talk about consent in a second. So it's an affirmative defense, which means that the burden is on the defense to prove that this is what happened, that this was a consensual issue. The burden is not on us to disprove that. The defense has to raise it. The defense has to argue it in the affirmative. So that is just something that's going to be an issue potentially in any case if someone is saying that it's consensual. Usually the circumstantial evidence will kind of rule that out or suggest that that's not really reasonable to believe that this person was agreeing to strangulation to this degree. All right, so how is the offense graded? A violation of this section constitutes a misdemeanor of the second degree. So a second degree misdemeanor carries up to 2 years in prison and up to a $5,000 fine. That's just for the basic strangulation statute that we just went over. There are some additional provisions that elevate the seriousness of this offense based on the circumstances. And this is also, to me, very good in the law that you guys have passed. Under paragraph 2, a violation of this section shall constitute a felony of the second degree if it's committed against a family and or household member. So your family or household member, your domestic assaults, that's what we want to target. That's where we most see strangulation, and those are the folks we really want to protect, and this does that job. So a felony in the second degree carries up to 10 years in prison and up to a $25,000 fine, so that's going to make it more serious. A family or household member is going to be the current or former spouse, people who are living as spouses, either currently are living as spouses or formerly lived as spouses, people who are former or current sexual or intimate partners, parents and children, or people with a child in common. So it is defined in your Pennsylvania statute, and those are the essential folks that would fall under this. So these are the people that we're looking to protect, anyone who could be at risk of domestic violence and then at risk of strangulation as well. So that's going to make it a felony. Previously, somebody asked a question, and I think I have a question right now. So does the statute not cover positional asphyxia? All right, so I don't know. Because I don't know exactly what positional asphyxia. I think that is where someone would get someone in such a position that they can't breathe. They're either bent over or being pressed upon in a way such that you just simply cannot breathe. And the way I read this statute is it's either going to have to be around the neck or hands or mouth. So if for positional asphyxia, if I'm correct in what that is, where someone might be, if you've ever had someone stretch you and you get your knees into your chest and you press down, at a certain point you can't breathe, and that would not be covered under this statute. And I think the person is going to clarify on what, yes, that's usually by applying pressure to the chest area is what positional asphyxia is. That would not be covered under this statute, as I read it, because it only mentions the hands are around the throat and the nose and mouth. So that's a great question, and that's something to think about, and that can happen. We did have a previous question about whether strangulation against a family or household member, whether officers could do a warrantless arrest in those cases, because there's a special statutory exception for certain domestic violence offenses under Pennsylvania law where an officer can arrest without a warrant when he has probable cause to believe that domestic violence has occurred. Most states have that. We did in Virginia. There was exceptions for domestic violence and shoplifting, oddly enough, that you could do a warrantless arrest. But there's also an exception for any felony that is not committed in the officer's presence that the officer has probable cause to believe occurred. An officer can make an arrest in those situations as well. And because your statute makes strangulation against a family and household member a felony, then the officer can still do those arrests, just like he would in any domestic violence misdemeanor. So that's a good thing in that situation too. It's also a felony of the second degree where a caretaker, the strangulation is committed by a caretaker against a care-dependent person, and there's a statute that defines all of the different relationships, all of the different individuals that would be covered under that. I'm not going to go into that, but if anybody wants to know it, you can reach out to PCADV, Rachel Pinsker, or you can reach out to me, and I'll send you what that statute says and who's covered. Also, if the strangulation is in conjunction with sexual violence or conduct constituting a crime under the sexual violence-related statutes, or a stalking incident, or if it's related to human trafficking, that's going to be a felony in the second degree. Someone is commenting that a family or household member also includes relatives by blood or affinity, so that is someone else who's going to be included in those situations under the family or household member. So it will be additional individuals than the ones I literally just mentioned. All right, so let me move on from here. So a violation of strangulation shall constitute a felony of the first degree, and I think I did cover that. It does not cover positional asphyxia. This statute would not cover that. The only activity that is covered is pressure around the neck and covering the nose and mouth. All right, so the felony in the first degree occurs when there's strangulation and the defendant is subject to an active protection from abuse order or a sexual violence or intimidation protection order that covers this victim. So if the strangulation occurs while those orders are in effect and that individual involves the victim and the defendant is the respondent, that elevates this to a felony of the first degree, which carries up to 20 years in prison and up to a $25,000 fine. It also is a felony in the first degree if the defendant uses an instrument of crime in commission of the offense. So if they use some instrument of crime, it usually has to be something that is intended to be used in crime. It can't be sort of any device, but something that is associated with criminal behavior. So if that is the situation, then that would make it a first-degree felony. And we usually think of firearms as instruments of crimes in a robbery, that sort of thing, that where somebody uses a gun in a robbery type situation, or somebody has burglar tools or something like that. So that would be covered. It also becomes a first-degree felony if the defendant has previously been convicted of an offense under paragraph 2, which are the felonies related to a family or household member. The offense is done by a caretaker or in conjunction with sexual violence, stalking, or human trafficking. So it wouldn't become a felony because of paragraph 1 if it's just a misdemeanor strangulation. And the thing to think about in that situation is sometimes in plea agreements, in cases that might be difficult, we might say, you know what, we'll agree to reduce the felony strangulation to a misdemeanor strangulation. And your statute does not allow that misdemeanor prior as an enhancement. So I want to be careful if we get into that situation. I don't want to automatically reduce it to a misdemeanor. Sometimes, you know, the case is what it is, and we have to do certain things to get that hook in the defendant if that's the best course of action. But we don't want to routinely do that because that's not going to give us enhancements down the road. Paragraph 2 will give us enhancements potentially to a first-degree felony if there is a prior felony of the second degree under paragraph 2. So just something to think about as we're approaching these cases. Also, if the defendant has been convicted not only in Pennsylvania but in another jurisdiction under a substantially similar law, there's certain hoops you have to jump through to demonstrate that another jurisdiction's law is substantially similar to your own, and we can certainly help you research that and demonstrate that it is substantially similar, or it may be that it's not substantially similar. So we can help you with that if you find yourself in that situation. You run the criminal record and find out somebody was convicted of strangulation in Virginia or New Jersey or California. We'll pull their statutes and compare the elements and research the case law that dictates how you demonstrate substantially similar crimes. All right, so this is the section on consent to bodily injury. When conduct is charged to constitute an offense because it threatens bodily injury, consent to the infliction of such injury is a defense if the conduct and the injury are reasonably foreseeable hazards of athletic contest. So if you're involved in a sporting event and you get injured, now strangulation obviously is not something foreseeable in a typical sporting event, but it might be in like an ultimate fighting championship where they do engage in certain things like that. It's a defense if you're engaged in that, and strangulation is part of it. If you're playing football or basketball, strangulation is not foreseeable, and that is not something that would be a defense. If the consent establishes a justification for the conduct relating to the general principles of justification. So that justification is where you're committing a crime, you know you're committing a crime, but you're doing it for some compelling reason. I am not allowed to possess a firearm because I'm a convicted felon, but I did to scare off a burglar or to protect some third party. That's usually where justification. It's hard for me to see where strangulation would be justified, but it could be if you're defending some third person and you're trying, or self-defense is different from justification, but that might be an issue there as well. There are a few incidents where it's ineffective, consent is going to be ineffective. If it's given by a person who's legally incapacitated to authorize the conduct charged to constitute the offense. So someone who cannot do that, either for various reasons. It could be, the number 2 list ticks off all the reasons that I would typically think of in this situation. If it's given by a person who by reason of youth, so certain people under a certain age couldn't agree to engage in sex or rough sex or any sex because they're too young. If a person has a mental disease or defect, someone who's suffering from a mental illness, or someone who has a cognitive disability, things like that, they may not be able to do it. Someone who's intoxicated and unable to, or known by the actor to be unable to make a reasonable judgment as to the nature or harmfulness of the conduct, can't consent to it. So those are ineffective. This third one, I'm not 100% sure what it is. It might be an old holdover, but by a person whose improvident consent is sought to be prevented by the law, defining the offense. So if a law is designed to protect people from certain behaviors that you just can't consent to, you can't really consent to, like having someone kill you or things like that, unless you have an assisted death with dignity, assisted suicide statute. So it might be something along those lines. And the fourth one, you can't consent if it's induced by force, duress, or deception. So it's not consent if someone frightens you, terrorizes you, threatens you into consenting to somebody, or tricks you into consenting to something. So those are just your ineffective consent laws. Just something to think about. That I don't think is going to be a typical defense, but it does crop up from time to time. And again, in my experience, it's usually associated with sexual behavior rather than in just a domestic assault situation where a victim's going to say, "Oh yeah, I said he could strangle me." It's going to be a little odd. We also want to think about strangulation and how it might co-occur or interrelate with other crimes. Obviously, we know it's associated with intimate partner violence, and we now do a much better job paying attention to that, identifying it, and maybe even proactively asking about it, particularly when we're doing lethality assessments with victims. It also can be associated with sexual assault and obviously is associated with homicide because that's often how some of these domestic violence homicides occur through strangulation. So we'll talk a little bit about, and I'm not a medical professional, so I'm only going to talk a little bit about the mechanism of strangulation and the physiological things associated with strangulation. So you have your carotid artery here in red that is carrying oxygenated blood from the heart to the brain. And when we put pressure on the neck, that can get blocked such that it deprives the brain of oxygen. This is what can cause people to react oddly or to pass out, to become unconscious. The jugular veins, which are on the very outside of the neck, the carotid arteries a little more inside, they're carrying blood down from the brain back to be oxygenated through the heart and lungs. So those are much easier to get obstructed or impeded by pressure because they're more on the outside of the neck. This can cause blood, if there's pressure there and it's blocking the blood flow, it causes the blood to get backed up, and it can cause what we call or refer to as petechiae, which are those burst little blood capillaries. And if you've ever had a strangulation or a suffocation case, I had a case where the husband suffocated his wife with a pillow over her mouth and face. It can cause those things to happen and cause the petechiae that cause those blood vessels to burst. So we often see it associated with strangulation, where that pressure occurs and stops the blood flow. It backs up and causes those to burst. It may be associated with other things, so it doesn't automatically mean strangulation necessarily. Talk to your medical professionals, and they'll tell you all about that. Further in is going to be the trachea, and we'll look at that in a little bit. That takes quite a bit more pressure to block the trachea or impede the airflow that way, but it can happen. So the carotid artery occlusion, meaning we're blocking or stopping the blood, can occur with just 11 pounds of pressure and for just 10 seconds. So that happens very quickly and can be very dangerous. The jugular vein occlusion is a bit less pressure, 4.4 pounds of pressure for 10 seconds, and you're going to have that blocked and back up. 4.4 pounds of pressure, someone described that to me as similar to the amount of pressure necessary to pull the trigger on a gun, if that's a good analogy for folks to recognize how little pressure that requires. So it doesn't require a lot of pressure, and folks can reach unconsciousness within 10 seconds with that amount of pressure. That's how quick this can happen. And I've seen that in videos where it happens just that quickly. So we recognize, again, how dangerous that is. Tracheal occlusion requires a little more pressure, 33 pounds, or I shouldn't say a little more, quite a bit more pressure to completely occlude. And it's usually not related or associated with death, as opposed to a fracture of the trachea, which could be more associated or related to death. At least 33 pounds of pressure or more to fracture tracheal cartilage. So that requires a bit more pressure. It might be an indication, if you do have that fracture or that injury, that there was quite a bit of pressure going on in that situation. So some of the things that affect how effective strangulation is going to be are, one, the anatomic location of the applied force. So depending on where you're getting that force, if you're actually effectively hitting those veins to block that blood flow, depending on how an offender's hands are placed, that will affect how effective the strangulation is. How long, the duration of the force, how long that is applied there is going to affect the effectiveness. The quantity, how hard you're pressing down affects it, and the surface area of the applied force. So a ligature, that rope or chain or cord, that's going to have a very focused applied force, and it's going to be very effective in incapacitating somebody or killing them. When you use your hand, the force is diffused a little more and may not be quite as effective, but of course it can be just equally as dangerous and cause injury and death as well. That can come from strangulation for all these different things, the cardiac arrhythmia, preventing the blood flow to the brain for an extended period of time, the blood backing up, and pressure on the larynx cutting off airflow. So it's extremely dangerous, and it can cause fatality in several different ways. There's also the risk of delayed fatality, and that's something we need to think about, and the reason why people need to be assessed after any report of strangulation. You know, even if they are reporting strangulation happened days ago, or he did it once a long time ago, I'd still want that person maybe to just receive a medical evaluation, just because if it happened a lot, there could be ongoing neurological symptoms or other issues related to it. But if it happened very recently, there's this risk of delayed fatality through this dissection of the carotid artery, complications to breathing, pneumonia, or this acute respiratory distress syndrome. So I don't really know what all those things are. A medical professional needs to do that. EMTs need to receive training, and a lot of victims don't want to do that. I think it's just like a human nature thing. I feel okay. I don't want to make a big fuss. I don't need to see a medical provider. At least get them to see an EMT because they're going to have a little more knowledge about this, and they may be receiving dedicated training to strangulation as well. I don't know that that's happening everywhere, and if it's not, it should be, because they may be the only ones that a victim is going to see at the scene rather than go to the hospital. We really want to encourage people. It's such dangerous behavior. We want to encourage people to get a medical assessment, to receive medical treatment, to go to a medical facility and get proper treatment. But failing that, let's get an EMT, someone who can provide some sort of assessment right on the scene and then provide some additional advice. So this is some documentation of the 4 stages that patients describe as they're going through an event involving strangulation. So the first is denial, that they just couldn't believe that this was happening. So you can imagine somebody suddenly does that and you're just like, what is going on? Then they realize, oh, this really is happening. And then there's that primal struggle to survive, where they're, you'll often have victims with severe gouging injuries, clawing marks on their neck that they have inflicted themselves trying to get perpetrators' hands off their neck. And that's that primal struggle for life. They're really trying to get it. And then that last stage is just resignation. And these are obviously from victims who experienced loss of consciousness, weren't killed, but they just things that were popping into their heads like, I hope my kids will be okay, or I thought he was going to kill me. So those are those 4 stages. That's important evidence to ask about, because these are sort of things that people can't really make up. And when someone can tell you, this is what was going through my mind while he was strangling me, that might move that case across the line for your judge or jury. It might be extremely impactful. So let's ask about that. What was going through your mind as this was going on, and see what they tell us. Not every victim is going to give you these stages. Not every victim is going to give you compelling evidence. They might just say, I don't remember, or it might be difficult for them to recall those things because it was so terrorizing. But we should ask about that because it can be valuable evidence in these cases. All right, so we'll talk a little bit about investigation and some questions to ask. Obviously, we want to document everything we can when we have a report of strangulation. So taking pictures of the any visible injuries, or I would just take pictures, period. I don't care what it is. Let's just document it. If it doesn't show injuries now, maybe we follow up a couple days later and then bruises appear. Or we alert the victim that if bruises do appear, please take pictures of them. But it's better if the police officer reports and takes them themselves. We want to just document the situation, so whatever that is. But we also want to document any symptoms that the victims report. So let's ask a lot of questions about what happened. So how was the victim strangled? What was the method? Was it like this? Was it some sort of form of hanging? Did he somehow get a rope around them and do something? Was he using a ligature and he just pulled it tight around them? Let's find out what happened. How many times has the victim been strangled? Either during this incident, did he let up? Did he do it again? Did it happen repeatedly over the course of a day? Or has it happened repeatedly over the course of a relationship? That's important, not just for our case, and it doesn't just help us as investigators and prosecutors figure out how dangerous the individual is that we're dealing with. If strangulation is occurring, I already know this is a dangerous person. But if it's been happening a lot, then this victim is in serious danger of lethality and probably already has some consequential health concerns related to that. So we definitely want to get them to medical. Was the victim shaken simultaneously? Can some injuries, whiplash or other injuries, be explained by that? Did the victim hit their head? Was there a concussion? These things are going to help a medical provider, but they'll also help us determine whether symptoms can be explained by another injury or if they are related to the strangulation. So feeling dizzy is something that I think an expert would tell me is associated with an impediment of blood flow to the brain or having a headache afterwards. But if you hit your head, it might be also could be explained by other things as well. So I want to know what my case is going to be going in. So I want to ask these questions. Does the victim feel faint, dizzy, or lose consciousness? Did they pass out or black out? Remember, victims use terms differently. So a pass out and a blackout technically are different terms, but to them it just means that they went out, they lost consciousness. So it's fine to ask it that way, as long as we determine specifically what they're talking about. Did the victim have trouble breathing during or after? Obviously, that's going to be critical to proving the impediment of airflow, which is right under the statute, so we want to know that. Did the victim hyperventilate afterwards? That could be an indicator that they were strangled, there was an impediment, and now they're having difficulty breathing afterwards. Was there any trouble swallowing, any pain in swallowing? Is there any drooling, meaning that they cannot swallow and so they start to drool or they're spitting? Were there any voice changes? Is their voice hoarse, raspy, or do they have a loss of voice, or they can barely be heard? We don't know every victim, but when we arrive at the scene of a domestic violence assault, so we might want to compare it to their voicemail on their phone, or maybe in a few weeks, just to compare, record their voice at the time of the report. Maybe it's recorded on 911, and then we can compare it to their normal speaking voice later. Is there any coughing? Does the victim have neck or throat pain? And where specifically do they have that? Did the victim lose control of bladder or bowels? That's obviously going to be an extreme case of strangulation where it reaches that point, and I want to know about that. And a victim might not want to share that. That might be embarrassing to them. They may not recognize that that's an important piece of evidence. So let's ask proactively about the bladder and bowel control. Did the victim feel nauseated or vomit afterwards? Again, serious strangulation incident, that's important evidence. I want to know about that. And these things, the bladder and bowel and the nausea and vomit, these are things I think a judge and jury are going to recognize, oh, this is serious. This was a serious incident. So let's try and collect that in evidence every time. Some police department domestic violence report forms will include a strangulation section. Where I practiced in Virginia, the Virginia Beach Police Department has such a form, and it has a whole section on documenting strangulation, signs and symptoms of strangulation. A sign is that visible physical sign, marks, redness. A symptom is something that the victim tells you about. It's painful to swallow, and you can document all of that. Is the victim pregnant? There might be an increased risk of miscarriage in strangulation cases. I don't know that the research is conclusive on that, but it's something that we should be concerned about and make sure that if the victim's pregnant, the baby's okay. What did the suspect say when he was strangling the victim? And use quotes because they're threatening to kill them during this incident. They could be saying other things. That's going to be important evidence if the victim recalls it. Sometimes they may not recall other things that are going on around them because of the terror of the strangulation itself. What did the victim say to the suspect, if they were able to talk, if anything? Or what did they say immediately prior or immediately afterwards? What did the victim think was going to happen when strangled? Let's ask those questions about what was going through their mind. That's going to be important. I was going to die. I could only think of my kids. What caused the suspect to stop? Did the victim pass out? Did somebody else intervene? Did they just stop? Find out about those things. Did the victim attempt to defend themselves? And can we identify injuries to the defendant that are consistent with the victim defending themselves, like a bite mark where around here that might indicate hands around the neck or something like this around the neck? Was the incident witnessed? Did children witness it? Were they present? That could be an additional charge. We want to charge every crime possible, but endangering children could be another charge that we are able to prove maybe more ably than domestic violence charge or strangulation charge. Were there any pre-existing injuries to the victim or the suspect? So we can eliminate those if that's from some other unrelated incident. That helps us. Any prior incidents of strangulation, we always want to know that. Is there a history of domestic violence? Almost certainly there's going to be. Whether the victim's ready to share that with you or not is another question, but we should ask about that. And we should ask that question in every domestic violence call. The history of the relationship is the key to winning these cases, so that's what I need to know. Did the suspect force the victim to engage in sexual conduct? So that's not necessarily related to strangulation, but could be associated with extreme lethality, risk of lethality, because that's another red flag in a domestic relationship when there's forced sex. Document everything. If there's a ligature, collect it, photograph it, document quotes and detail them in your report, record the interviews. If you have body-worn cameras, those are great evidence in these cases. Look for injuries on the suspect's hands, arms, chest, neck, and face. Just want to document all of that as well. Or if there's lack of injuries, document that. Photograph his injuries or his lack of injuries. And ask about injuries that can't be seen. Are you in any pain? Are you suffering from anything? I don't want the suspect to create some injury later on that we didn't ask about. All right, some quick prosecution strategies. This is a quote from an article about strangulation. Non-lethal strangulation of intimate partners has a lot of health effects and is associated with increased risk of later lethal violence by a partner or an ex-intimate partner, but can be difficult to prosecute under felony assault statutes. And that's very true. Felony assault statutes often require bodily injury, things that we can demonstrate there was injury to. Your strangulation statute no longer requires that, or doesn't require it now, rather, and so that's an advantage for you. This is a case out of Minnesota. Because they have one of the older strangulation laws, they have some case law related to what you have to prove. And so this is what they found was sufficient, that the defendant held her down and was pushing on her throat until she had trouble breathing. So if we have that evidence, that's going to help us. The victim told the police and medical personnel that her throat hurt and it was swollen. So that's going to be helpful. The medical witness testified that although JP, the victim, did not have obvious bruises or petechiae, those are those little burst blood vessels, she had other signs of strangulation, including a painful throat and difficulty swallowing. So they're able to document those things, and those are consistent with someone having been strangled. Other things can cause that too, but given the victim's report and the report of symptoms, that is consistent with strangulation. Strangulation requires only the impediment of normal breathing or circulation of blood, not the full cessation of breathing or blood. So don't let the defense sort of try and do that. All you have to do is impede it. It doesn't mean she couldn't breathe at all, that if we only can show she couldn't breathe at all, that would make it strangulation. If she had difficulty breathing, that's fine, and those are the questions we ask. That lack of visible injury is a challenge, potential for delayed fatalities, which we talked about, and the indicator of dangerousness we talked about. Sometimes proving intent can be difficult, particularly under old felony assault statutes. I don't think that's going to be an issue under your statute. If someone is applying pressure to the neck or covering the nose and mouth, that's going to be circumstantial evidence that they intended to cause the impediment of blood and airflow. So I don't think you're going to have a problem with that. Charging considerations, remember under your statute, was a ligature used? That could, if it's an instrument of crime, it may or may not be considered an instrument of crime, but that could elevate it to a felony. That also makes it much more dangerous, so we want to think about that. Is the victim a family or household member? That's going to make it a felony. Was a protective order in place? That's going to make it a more serious felony. Is there a prior conviction under your Article 2 or under a substantially similar statute? That's going to make it a more serious offense. And was it related to sexual violence, stalking, or human trafficking? It's going to elevate it to a Class 2 felony or a felony of the second degree under your law. We want to educate our judge about the dangerousness of strangulation, and in bail hearings, we want the judge to know this is extremely dangerous, not just because it's on these lethality assessment forms, but because of all the physical harm it can cause. And so you might want to do what we might call a dog and pony for your judge once or twice, or your different judges, so that you have an expert to talk about not only lethality, but a medical expert to talk about how dangerous this is. This is somebody who doesn't need to get out or not get out easily. So let's try and keep these victims safe by keeping these guys locked up. This is a Pennsylvania case where death was caused by strangulation, and it was sufficient to infer the requisite intent in a first-degree murder case, so that we would have to specifically prove that intent, and that strangulation was sufficient there. So that is a case that potentially could be used if someone makes an intent argument. Expert witnesses are really important in these cases, and I'm really talking about the medical professionals who can assist you through the investigation, charging, maybe motions preparation. Of course, you're going to want to, if you're going to call them, you're going to want to prepare them properly. They can help you out at trial as an expert witness, but they can help you out before trial too. So think about talking to expert witnesses in these cases. We definitely have to be careful and go over police reports and witness testimony, get any 911 recordings, find out about the police action and medical treatment that was provided, whether on scene or later, medical expert testimony or medical fact witness testimony, those facts that the reports of painful swallowing, sore throat, or visible injuries that they observed. Physical evidence recovered, we always want to do that. Take pictures, document the scene, get any ligatures that were used, and get those medical records. This is 404B, or prior crimes and other acts evidence that we can sometimes get in, and this is a Pennsylvania case where they were able to get in a prior incident of strangulation that wasn't exactly identical to the previous one. The homicide case where he murdered and raped the victim was using a phone cord. The prior incident, he didn't use a cord, but they still allowed it in. There's a quick question here. Please briefly discuss the fact that sexual assault is better not written versus documenting strangulation. Is that fact that sexual assault is better not written versus, I'm not sure I understand what the question is. If you're talking about how we're documenting either statements, et cetera. If you can clarify that, I'll try and get back to that as we come down to the end. Again, we're going to meet these challenges associated with strangulation and domestic violence, starting with jury selection and voir dire. Our opening statements, we're going to have a theme, and we're going to hit on that theme, how dangerous strangulation is, the ultimate act of control. This isn't about an argument that went bad. This is about power and control. That's a common theme in domestic violence cases. We're going to use direct, cross, and closing, and we'll always have that theme and theory in there when we're talking about this. As we're going forward in these cases, we're always going to document signs of strangulation, whatever they are. Visible signs, the symptoms the victims report. We're going to ask the victims about those things. We're going to take into account the increased risk and lethality of strangulation, charge appropriately. Are you bail appropriately? Are you sentencing appropriately? And we're going to do all of these things under Pennsylvania's new law, which is going to cover a lot of activity that we associate particularly with domestic violence. So please take a look at that law. If you need any help with it, the folks at PCADV can help you with it. We're here to help you with it as well. We can do research. We can help you with motions, expert testimony, hooking you up with experts. So please take advantage of the resources that you have. And I think you're going to find this new law is going to be very helpful in a lot of these cases. So thank you very much, guys. And let me see if I have, I've got the 3-minute warning, and I think I might be getting, can you recommend resources on trauma? Oh, there is another slide. Resources on trauma and memory and how trauma harms memory. Yeah, there's a lot of that. Here are some resources related to strangulation. But we know through the neurobiology of trauma and talking with experts who've studied this that these kinds of traumatic experiences, we mostly have research related to the trauma of sexual assault and how that impacts memory. I think this would probably fit right in line with that. The trauma of this severe incident could affect a victim's ability to recall exactly what happened or to recall it in a linear fashion, certainly immediately at the scene. It may also be difficult for them to recall all of the things that happened over time. So we want to recognize that. And there are resources out there. Dr. Rebecca Campbell has an excellent online resource about the neurobiology of sexual assault that you can view online. And if you just Google Dr. Rebecca Campbell, neurobiology of sexual assault, you'll see it. This is my contact information, so if you need any information from me, please reach out to me, and I'm happy to help you out in any way I can. I don't have the answer to everything, and I don't have every resource, but we usually know somebody who has the answer, so we can hook you up with the person who would be appropriate to talk to. So please do reach out to me in those situations. I think somebody else might be typing a question. Let me see if I can. What if erotic asphyxiation is non-consensual, but a verbal no is not given? Okay, so the erotic asphyxiation are the people that are talking about rough sex and that sometimes strangulation is a part of it. We often have sexual assaults where the sexual activity is non-consensual, or you could have an unusual situation where the sexual intercourse might be consensual, but there was never a conversation about strangulation, and there's not a verbal no. In plenty of our sexual assault cases, we don't get verbal no's. It doesn't mean the person wasn't raped, and it doesn't mean we don't go forward. They're very difficult cases, and we have to look at a lot of the circumstantial evidence. We have to also look at the relationship of the two individuals, everything that happened that brought them together in this situation and everything that happened afterwards. And sometimes those circumstances will demonstrate clearly that this person never intended or never agreed or never consented to being strangled during sex. So we do have to look at those things. It also might just be possible that they couldn't say no because they were being strangled. But I'd want to know what happened afterwards and what happened leading up to it.